prosecutors?
Yes, I'm trying to reach Paul Safier, please.
Hold on. Hello?
Paul Safier?
Yes.
Lydia Radin.
Good morning.
Good morning.
How can I help you?
I sent you an email about 4 magistrate judges and at least 3, mostly more, prosecutors who are breaking the law. Here's what came out of discovery in my case. Court security officers are not, court security private contract guards are not federal officers for the purposes of charging 18 U.S.C. 111, assault on a federal officer. You know who knows all this? The Court Security Committee. You know who sits on the Court Security Committee? Let's talk about the Southern District. U.S. Attorney Preet Bharara, and Acting U.S. Attorney June Kim. The Chief Magistrate Judge, that would be Loretta Preska and Colleen McMahon. The Chief Magistrate Judge, that would be Deborah Freeman. You know, the Magistrate Judge who broke the law in my case. Let's see. Oh, U.S. Marshal Paul Greco and the Clerk of Court, Ruby Karadzic. They all sit on the Court Security Committee. So when they wrote me a ticket back in January 28, 2016, charging me with assault on a federal officer because they claimed I pushed a private contract intercon security guard, Frank Pinea, they all knew that was a fraud. That's a Class A felony that I got arrested for. There's videotape. Magistrate Pittman is watching the videotape of me being arrested, handcuffs being put on me, thrown to the ground, beaten, arrested without a warrant, and not taken in front of a judge without unnecessary delay. And a complaint was not filed promptly, according to the Supreme Court, within 2 days in the Federal District Court. Oh yeah, and released on my own recognizance within 21 days. There should have been a preliminary hearing. This is a Class A misdemeanor they're trying to charge me with, so that I could preserve evidence, which they destroyed. And then within 30 days, they were supposed to file a information or indictment, which they didn't do. That means within 30 days, they couldn't proceed with a criminal prosecution. And guess who knew? Magistrate Moses, who has access to an electronic database that you don't see because there's a federal ticket scam. Are you still with me, Paul Safier?
I am listening.
Okay. They write a ticket. They wrote a ticket. You know those CVB tickets? They never open a case. I confirmed with Central Violations down in Texas. Central Violations in Texas, the Central Violations Bureau in Texas, that's not a court. You want to talk about Moore's federal practice? Moore's federal practice says those notices to appear letters. They send out notices to appear letters. You ignore them. That's not a summons from the court. They never open a case in the Federal District Court, which means they never engage the court, which means the prosecutor never gets the power of the court. So what they do to prey on the ignorance and trust of the general public is they send out these notice to appear letters. You go down to the federal court. There's the prosecutor in a back office using the physical location, the courthouse itself as a front. And then he sits there and he smiles at you and tries to get money out of you and bullies you. Says, and this is what they did in 2015. Oh, this is $250, Miss Radin, but you know, we're going to be really nice. Just pay us $75. Really? How did you open a case? Where's the docket number? And as soon as you start asking those questions, suddenly your case disappears because the prosecutor never engages the power of the court. It's a fraud, a con, a scam, a RICO enterprise, a criminal enterprise. And then when I started asking questions at the end of 2015, how can you dismiss my case? What's the docket number? Where's the signed court order from the judge with the raised seal? And then when I started asking questions to Deborah Freeman, that's when they really came after me. So they beat me up on January 28, 2016. I'm arrested without a warrant. These are all Fourth Amendment violations. They don't take me without unnecessary delay in front of a judge. There's no complaint filed promptly. Promptly is defined by the U.S. Supreme Court as within 2 days. The complaint is supposed to be sworn to under penalty of perjury. It's the initiating document for a criminal prosecution in the Class A misdemeanor that's supposed to be filed in the Federal District Court. Within 21 days, they're supposed to give me a preliminary hearing so I can say, save that videotape so I can prove all the DOJ personnel who were involved in this fraud. Within 30 days, they're supposed to file an information or indictment, but they don't do that. So when they violate the federal rules of criminal procedure, they're breaking the law. When they break the law, they lose jurisdiction. I get a writ of prohibition as of right. I get a writ of mandamus as of right, because there's nothing more prejudicial than judges breaking the law. The prosecutors breaking the law too. So when I go down in April and May in response to the notice to appear letters from Central Violations Bureau, which is not a court, and I write to rejected with for cause on the notice to appear letters that I'm supposed to do. You want me to give you the page out of Moore's Federal Practice? Those reminder letters are garbage. There's no summons from the court. The prosecutor has never engaged the court or gotten the powers of the court. But instead, what the prosecutor does on May 17, 2016, he or she uses the court, the physical plant, the location of the court itself, as a front. And you go down there and you sit in the back office with the except I wasn't stupid enough to do that. I brought witnesses, and I made the prosecutor come out and talk to me. And as soon as they got hip to the fact that I wasn't that stupid, Magistrate Moses reviewed my case, which means she has access to an electronic database that she logs into, and she can see on the electronic database that they're trying to charge me with a Class A misdemeanor written on a federal violations ticket. And a case is never opened in the federal district court, which means my case should have stopped immediately upon review by Magistrate Moses on May 17th, 2016. But that's not what happened, because they wanted the prosecution. They want a fake prosecution to drop me into jail. You know why? Because I caught Stephanie Lake lying. She went to court as a federal prosecutor and said, as an initial matter, Miss Radin was never placed under arrest. And the court security guard, the private contract guard, not empowered by law, not a federal officer, states on the record, oh yeah, I placed Miss Radin under arrest. And then we're all looking at the videotape where the handcuffs are put on me, where he beats me, where I'm not free to leave. I'm not placed under arrest. They incriminated themselves. Now it's June, and I got June 2016, and all of this is being carried on a central violations docket where they never open a case. That's a fraud. That's a racketeering fraud. And I got that down in June. And guess who's accepting my paperwork? Oh, this is great. April, May, June, July. I'm going down to Vincent Bambino, the court clerk on the 5th floor, and his supervisor, Daniel Ortiz, on the 5th floor. And I'm giving them my paperwork. And they're stamping received on it, and they're signing it, and they're dating it, and they're smiling in my face saying, oh, yes, we're accepting your paperwork, Miss Radin. And I'm like, really? Where's the docket? Where's the index number? What's the docket? Where's the case? Can I see where you're filing all this stuff? And they're smiling, swearing to God they're filing all they can't file my paperwork. They never opened a case. Each and every time they did that is an affirmative act of fraud, of a RICO scheme. Oh, and then Chief Magistrate Judge Deborah Freeman gets involved in June of 2016, and she knows because she can sign, and all this information about the secret database is all being kept away from you so I can be deluded and deceived. And in June 2016, Magistrate Freeman looks at the docket, and Stephanie Lindsay Lake, you know, the woman with the Ivy League law degree who's clerked for 2 judges. Oh yeah, and Michael Ferrara, the AUSA with 13 years of experience, all colluding and conspiring. And in June, I get the chief magistrate judge who can sign into an electronic database and see you're being charged with a Class A misdemeanor, and a case was never opened, and all the things the prosecutor was supposed to do, they didn't do, and they broke the law over and over and over again, so they lost jurisdiction. They didn't even obtain jurisdiction because they never opened a case, and they're doing it to how many people each month in Central Violations Court? Lying to people? Trying to fool them to think, oh yeah, you got the notice to appear, so you come down, you engage the court, you're trying to explain things, because all these stupid people honestly and sincerely trust the prosecutor. They don't think the prosecutor is lying to them. He's a crook. They're all crooks. And then they're trying to deceive you that because you came down, they got personal jurisdiction over you. They can't get personal jurisdiction over you because they never opened a case. They never engaged the court. They used the courthouse as a front, as window dressing, as a shakedown, as a con. So this is happening in June, and I go down again, and Magistrate Freeman is looking into this, and she's supposed to be dismissing all this, but no, I get another notice to appear for July 7th, 2016, and I go down July 7th, 2016, and I say to the lady, you don't have subject matter jurisdiction, you don't have personal jurisdiction. And what does she do? She pretends to put blinders on, and then she incriminates herself. Oh yeah, this is a Class A misdemeanor, simple assault, charged by way of a federal violations ticket, and on July 7th, 2016, there was not an open case. She proceeded without jurisdiction, without authority, in defiance of law. 18 U.S.C. 2384, sedition, felony sedition, subversion, treason. You got a judge sitting on the bench with guilty knowledge that there's no open case, and the prosecutor has broken the law over and over and over again. And what does she do? She continues in the fraud and the delusion. And everybody in that courtroom, including Shane Doyle, Max Vallis, Homeland Security Inspector Justin Green, who's charged by law with protecting me under 40 U.S.C. 1315 with offenses against the United States. They're committing felony sedition. Shane Doyle, Max Vallis, the court security guards, the marshals, and Homeland Security, Justin Green, is charged by law with protecting me from the crook on the bench who's breaking the law, and the two prosecutors who are breaking the law. They're supposed to be protecting me. 40 U.S.C. 1315. These are offenses against the United States. This is irreparable harm that can never be fixed. They are breaking the law to destroy our government of laws, and they're doing it knowingly, willfully, intentionally, with criminal intent. They get up in the morning with evil in their hearts and go down to the courthouse and commit crimes. They know what they're doing. Hello? Oh, but it gets better.
Patiently listening, Miss Radin.
It gets better. And then on July 7th, when I confront Magistrate Freeman and she incriminates herself on the record with the transcript I've already submitted, then she starts coaching the prosecutors into, listen, you can't charge Class A. You kind of blew all the federal rules of criminal procedure here. Why don't you try this or try it? There's not an open case. And when Magistrate Freeman gives order, and I tell Magistrate Freeman, this is garbage. I'm going down to the clerk of court and filing my default. I don't know what the hell you people are up to, but this is Fourth Amendment violations each and every time. From January 28th, 2016 to now, July 7th, 2016, I'm going down to the clerk of court and I'm filing default against you people. And I'm going to start charging you for all my time and money that you've wasted for me coming down here, and you never even opened a case. This whole thing is a fraud. What does Magistrate Freeman do? She doesn't want me to go to the clerk of court because then her fraud is going to be exposed. So she gives an order. And all these mindless bunnies, are you serious? Homeland Security Officer Samuels, all the court security guards, Justin Green, Deputy U.S. Marshal Shane Doyle, who's falsifying false intelligence reports, Jason W. Brazgala, Max Vallis, what? They all check their brain cells at the door? There's no case. Really? Stephanie Lake doesn't know? She knows. Michael Ferrara, 13 years of experience, doesn't know. So any orders that Magistrate Freeman may or may not have given are unlawful. She has no jurisdiction. She's proceeding without authority. She's a crook breaking the law in black robes, pretending in a farce and window dressing she can do something. And all the little handmaidens are pretending to be stupid because the emperor has no clothes and they know it. So, you want to beat me up on July 7th, 2016? Put handcuffs on me? Restrain my liberty? I can't leave the courthouse? Make up stories about how you're going to charge me so you can somehow try to cover up for all your Fourth Amendment violations? And then Samuel says, oh yeah, I arrested her. I never took her in front of a judge. Oh great, we're back to the Fourth Amendment again. Arrested without a warrant. not taken without delay to a judge. A complaint was not filed promptly, defined by the Supreme Court as within 2 days. Released on my own recognizance. A preliminary hearing was not given in 21 days. Oh, and then we get to the information. The information that was supposed to be filed within 30 days, it also wasn't done. So Stephanie Lake tries to get me indicted behind my back. She thinks I'm too stupid to know, but I know. So she filed, but it doesn't work, like in Berg's case, because they did the same thing to Berg. We'll get to Berg in a minute. Because in Berg's case, I'm the one bringing the information, the discovery materials that show that Don Addio, as a private contract guard, is not a federal officer for the purposes of indicting Berg. When I came to the courthouse on August 10th, 2017, with evidence, I have every right as a non-party witness, according to the Supreme Court, to challenge the jurisdiction of Berg's case. And I should not have been assaulted by someone who didn't even identify himself without even a name or a badge. But we'll get to that in a minute, because we're now back on August 3rd, 2016, when Stephanie Lake in the Southern District of New York files an information, and the information is a fraud on its face because it fails to charge a crime. 18 U.S.C. 113 charges a punishment. This is what's going to happen if you're found guilty, not a crime. And the Southern District of New York is it's not within, 500 Pearl Street is not within the special maritime and territorial jurisdiction of the court. According to, get this, the U.S. Attorney's Manual that says if you want to know the jurisdiction of the courthouse at 500 Pearl Street, you call Regional Counsel of the General Service Administration. That would be Carol Latterman, who I have on tape-recorded conversations in September 2016 discussing with me how the jurisdiction at 500 Pearl Street is proprietary, landlord-tenant, not special maritime and territorial jurisdiction, and not concurrent jurisdiction. And she even jokes with me about how Stephanie Lake called her to discuss this with her. So there's no deniability here. They all have guilty knowledge. They're all colluding and conspiring. So in more affirmative acts of fraud, I got Magistrate Deborah Freeman, whose first job is supposed to be looking at the information and knowing that the information has not obtained the subject matter jurisdiction of the federal court, and she's supposed to dismiss it on its face, but she doesn't do that. Instead, I get another bogus notice to appear, which I write rejected for cause on it, because notices to appear do not engage the power of the federal district court. And Stephanie Lake doesn't even serve me properly. She makes sure I don't even get the information until the day after the August 10th, 2016 farce, because it's not even a hearing. And on August 10th, 2016, Magistrate Freeman threatens me with arrest. And what she's got is an information that's a fraud on its face. She has no power to arrest me or threaten me. She's terrorizing me. She's trying to instill fear in me so I can have some U.S. Marshals who pretend to be dumb bunnies come to my house, grab me, beat me up, and almost murder me again. How many times are we going to go through this? So on August 10th, 2016, Magistrate Freeman threatens me with arrest. She doesn't have the power to do so. She's breaking the law. She has no authority, no jurisdiction. She's acting in defiance of the law. She's breaking the law. She's destroying our government of laws because she wants to make sure that she puts me in jail because I'm the one with the evidence that shows on July 7, 2016, she broke the law. She colluded, conspired. She created a fraud. Oh, yeah, in our district, it's a simple assault, blah, blah, blah. It was charged by way of a federal, and there was never an open case because she's being coached in state law, not federal law, to cover up for Alex Spiro suborning perjury, and Deputy U.S. Marshal James Howard knew all about it in 2009, and had he done his job, or Shane Doyle had done their job, or Sherry Robinson had done their job, none of this, I would have never been unlawfully incarcerated at Rikers Island and almost murdered. It's the U.S. Marshal Service that's trying to cover up for their collusion in breaking the law, in crimes, and destroying our government of laws, and the relentless persecution of Lydia Radin. So, to cover up for Dan Rozelle and financial fraud that James Howard knew all about, Deputy U.S. Marshal James Howard knew all about, because the last thing he wanted me to do was to go to the federal grand jury because he would be indicted. So now we're in August 10th, 2016, with Magistrate Deborah Freeman, who's got an information that's a fraud on its face, and she threatens me with arrest. Weigh in two attorneys, Christina Green and her boss, Joshua Levin, who know better, and lie for 2 weeks straight. And then I'm in front of Magistrate Andrew J. Peck, who happens to be an associate professor at Yeshiva University's law school. And he's sitting on the bench. And I dug out a case that's in the open public record from 2008 with Dan Rizal. You remember Dan Rizal, the private...
I remember the name.
Yeah, Dan Rizal, the private attorney who was paid by Yeshiva University to commit crimes, and I caught him. And he's a former federal prosecutor. When I start digging into all his cases, let's all see there's be a life's work for me. Dan Rizal's fraud after fraud. I'd love to get into his case files and see how many innocent people he screwed to the wall. But we'll get to that later, because I already caught Dan Rizal in financial fraud. I already have Yeshiva University stipulating to hate crimes, discrimination, and financial crimes against me. And that's what James Howard and the FBI should have been acting on, instead of covering up for Yeshiva University. Because the last thing they wanted from 2005 to 2010 was federal student loan fraud at Yeshiva University, just when all the Madoff fraud was coming up. Madoff stole $110 million from Yeshiva, and then what he didn't pick clean, the Board of Trustees picked clean. And you know who had a beat on all this? Rabbi Twersky, who was suing Yeshiva, because 35 men had been subjected to physical and sexual abuse at Yeshiva University, and I had the documentary evidence to discredit Dan Rizal. That place is not a school. It's a criminal enterprise, and they're destroying people's lives. So here we are on August 10th, 2016, with Deborah Freeman breaking the law. And by the way, you know, when she does this, that's not the primary harm. The primary harm is the felony sedition, the war that she's making in our government of laws to destroy our government of laws. This is an irreparable harm. It can never be fixed or remedied. The secondary harm is to me and to you and to other law-abiding citizens. I'm going to give you the benefit of the doubt here, Paul Safier, on this phone call. So now for 2 weeks, I get jerked around by two attorneys who know better, and on August 26, 2016, I'm in front of Magistrate Andrew J. Peck, who has a huge conflict of interest because he sits on Yeshiva University's, he's a professor at Cardozo Law School. He has a huge conflict of interest, and he sits on the bench. Because I have stipulations where Yeshiva University stipulated to hate crimes, fraud, and financial crimes, Peck has a choice. He either resigns from the bench or he resigns from Yeshiva, because according to the American Bar Association, he cannot do both. And Andrew J. Peck is supposed to say, I have a huge conflict of interest. I can't rule on this case. In fact, before he even gets there, he's supposed to look at the information. The information is a fraud on its face. Count 1 charges 18 U.S.C. 113, which is a punishment, not a crime. It's a fraud. And the Federal District Courthouse at 500 Pearl Street is not within the special maritime and territorial jurisdiction of the United States. The information is a fraud on its face. But what does Peck do? Peck bills a bond on top of the fraud. The bond is a fraud because it's built on the information, which is a fraud. And then they rig the wheel to send my case over to Magistrate Pittman. And Magistrate Pittman, the first thing he's supposed to do on August 27th, August 28th, August 29th, August 30th, August 31st, September 2016, is look at the information and see if it's valid, whether he has jurisdiction. And he doesn't. But what does he do on September 1st, 2016? He threatens me with arrest. He has no jurisdiction. The information's a fraud. It has failed to obtain the subject matter jurisdiction of the court. It is void ab initio. That's the first job Pittman's supposed to do, is say this information is a fraud and dismiss the case sua sponte, of his own volition. But instead, he threatens me. He has no authority to threaten me with arrest. He has no jurisdiction to threaten me with arrest. Subject matter jurisdiction cannot be waived. It doesn't matter how many times I come down and interact with the court. And you can't obtain jurisdiction, either personal jurisdiction or subject matter jurisdiction, by trickery and fraud. And again, he colludes and conspires with the prosecutor to break the law over and over and over again. And in breaking the law over and over and over again, they lose jurisdiction and they cannot go forward. But who do we have bullying me, threatening me? The U.S. Marshal Service, the goon squad for the crooks on the bench because they're not judges. So September 1st, 2016, Magistrate Pittman, Henry B. Pittman, a former federal prosecutor, so he knows better, broke the law. He had no jurisdiction to threaten me with arrest. He had no jurisdiction, no power of the court to compel me to come down. But he threatens me. And if these people put handcuffs on me again and kidney punch me again, I could wind up paralyzed or dead. I'm lucky to be alive right now.
When did that occur?
When did what occur?
You said again.
Frank Pinea beat me up on January 28th, 2016. It's in the videotape. I put it on the internet. In fact, you know, when he claimed to be arresting me, I'm January 28th, 2016. I go to a hearing. At best, I'm a non-party witness. I'm a litigant. I'm doing a motion to intervene as of right. I'm a protected person. Nobody has the right to touch me or Dean Lauren. He's another non-party witness. And according to the U.S. Supreme Court, we have every right to question the jurisdiction of the court, and we did. And so did Paul Gloria. And what Judge Pauly did was he struck, Judge Pauly made an order to strike. We were bringing evidence to show that our studio and the city of New York were deceiving Judge Pauly, that in fact Halleck's case showing that our TV studio and the city of New York was a state actor and that the Manhattan Borough President was intimately involved. We had meetings at the Manhattan Borough President's office. The Manhattan Borough President with Jessica Mates, the Chief of Staff, where we were discussing the unlawful censorship and banning of producers. And the power the city had to stop MNN from doing this, and we can show the coercive power. But the city knew they were in trouble, so they started fabricating a story that said, "Oh no, you know, the city has no power to interfere. They're not state actors." We're like, "What are you talking about?" We show up on January 28th, 2016. We got the evidence. Paul Gloria, here's evidence. Here's the email I'm getting from the Chief of Staff. Of course, the Manhattan Borough President has coercive power over our TV studio. Look at all the money they're collecting. Here's all the evidence. It shows that they do. And Judge Pauly put Paula Gloria's email on the record and scheduled a pre-motion conference for February 19th. And then after that, he struck it. He gave an order to strike it, but he struck those documents unlawfully. When you strike a document, the physical document stays in place, and there's a one-line strikeout on the description in the docket sheet. Would you like to see an example from the Bundy case about how documents are struck lawfully? Because the lower court record is supposed to be accurate, true, complete representation of what honestly went on, so that if the record was struck unlawfully and Judge Pauly's order was unlawful, the higher district court, the Second Circuit, could look at it. But by physically removing the document and then obliterating the description, what the lower district court clerk did was create a false court record by the sin of omission. And the second that happened, the Halleck case at the lower district federal court lost jurisdiction. And everything that happened after that striking, that unlawful striking in February 2016, means that Judge Pauly can't go forward, and he knows it. The Halleck case could never be entertained at the Second Circuit Court of Appeals because the lower district court lost jurisdiction by intentionally falsifying the record. And we have every right to go to the Second Circuit Court of Appeals and tell the judges we are non-party witnesses and we can challenge the jurisdiction of this appeal as per U.S. Supreme Court rulings. They're acting in criminal contempt of U.S. Supreme Court rulings. So I'm not supposed to be threatened by the clerk of court, Wolf, with, you know something, Miss Wolf? I wrote you 2 letters. My producers wrote you letters. We explained how this is very simple. It's not rocket science. I don't have to fight with you about putting my documents on the public record. I'll just communicate with the judges in private correspondence, because I can do that under 18 U.S.C. Section 4. I can report to any judge or military officer malfeasance in office, honest services fraud, misapprehension of a felony, crime, and the cover-up for crimes, with the expectation that the military officer and the judge will act, and act immediately, to put a stop to criminal contempt of Supreme Court rulings and other crimes. And what do I get from Miss Wolf? I get a threat saying, well, as a practical matter, Miss Radin, I control the mail that comes into the court. I'm like, really? And we start to have a conversation about this. So what you're going to do is control the flow of information to the purported independent judiciary, so you can obstruct justice, so you can manipulate the outcome of cases. That's not your job as a clerk of court. You don't have a court here. And really, you have staff attorneys that are reviewing the lower court record? The staff attorneys who are drowning in like 1,000 pages of garbage, when all they have to do is look at the docket sheet to know, oh, the record was struck unlawfully. The staff attorneys are colluding and conspiring. Oh, Mr. Robert Perry, the attorney for plaintiffs, who's a former assistant state attorney general. Because what the Halleck case is all about is an impermissible friendly lawsuit where the plaintiffs and the defendants conspire with each other to fabricate an outcome to create a barrier so that nobody else can sue. And they're trying to set a very dangerous precedent at the Second Circuit to be used across the country. So that any producer who's subjected to censorship or unlawful bannings can't sue the TV studio that's doing it because of the fabricated ruling at the Second Circuit Court of Appeals. Because a deal was made to keep Manhattan Borough President Gail Brewer's name off the public record, because she does have coercive power, and she demonstrated coercive power that MNN is a state actor, and Dee Dee Halleck's rights under 42 U.S.C. 1983 were violated. And that you don't ban any producer unless you have fair hearings. And this is what fair hearings look like. They don't want that. Because the CEO of our TV studio wants to be able to arbitrarily ban anybody or censor anybody anytime he wants, and they interfered in censorship in my case by telling people, going behind my back and telling people who to appear and not appear on my shows, and I already have sworn affidavits to that submitted in the court. And the Manhattan Borough President and the City of New York have coercive power, and they demonstrated it. And that's what they wanted to keep off the record, so they could fabricate a Second Circuit ruling that would be used against every producer nationwide in the 12 states left that still have public access.
And that's what was litigated in the Halleck case, correct?
That's what's being litigated in the Halleck case. The Halleck case is a bust. It can't get beyond Paula Gloria contacted Federal Judge Pauly, and on the record, the night before, and on the record on January 28th, 2016, Federal Judge Pauly says, I got this email from Paula Gloria, and I had caused it to be placed on the docket. What do you guys think? Blah, blah, blah. He's like, you know what? I'm going to schedule a pre-motion conference on February 19th. And Paula Gloria had the right, as of right, to intervene as of right. And instead, we got the city attorney, New York City Council, Emily Stillman, lying. Oh, no, it's not a state actor. Oh, no. And everybody wanting to keep Gail Brewer's name off the public record so she wouldn't be held accountable in the upcoming election. Except that we had meetings at the Manhattan Borough President's office with Jessica Mates. And Jessica Mates is preparing a draft letter on behalf of the Manhattan Borough President to say, what the hell are you doing? And the Manhattan Borough President did go down, and she did exercise her coercive authority in making sure, and the board, by the way, well, that's a lie too. They claimed there were 19 members on the board. No, there wasn't. By the time we contacted Manhattan Borough President Gail Brewer, the board was down to 5 members and was being run with a quorum of 3. One happened to be my representative, who never talks to us and is a rubber stamp, some guy from HBO, and Dan Coughlin, the CEO. So they're running Manhattan Neighborhood Network with a board with a quorum of 3, and there are no minutes. There's no where'd you spend the money? Where's the annual report? All of this is their fiduciary duty. They're not doing any of that. We have a right. Our representative is never meets with us. So how would she even know? In fact, I have tape recorded conversations where she says, "Well, I was instructed not to meet with you." Like, how can you be my representative on the board when you're instructed not to meet with me? What the hell is that? That's ridiculous. They're running M&M with a quorum of 3, not 19. There's no evidence on the record for any of those judges to rule, and they can't even get past when Judge Pauly ordered Paula Gloria's document to be struck. The court clerk struck the document unlawfully, and that's it. You lost jurisdiction. The Halleck case could not go forward. They all know that. This isn't rocket science. It's law school 101.
But my question was, has it gone forward? What's the status of that case?
The Halleck case is now at the Second Circuit Court of Appeals with a 3-judge panel.
Okay.
The case is stalled because once they committed the fraud in striking the record unlawfully, that's the first fraud, then they built a second fraud. And the second fraud was to attribute Paula Gloria's email, which is not only her communicating with the court, but also contains evidence. They destroyed evidence, because it contains Jessica Mate's email, which is evidence. This is the chief of staff at the Manhattan Borough President's office. Then they created another fraud because they wrongly attributed those documents to another producer. And then they tried to shut down the other producer, saying, "Oh, well, you can't do your own case because you already intervened, and your motion to intervene was ruled on and struck." But that's not true. That was not his paperwork. It was Paula Gloria's paperwork. So they built another fraud with the chief judge, Colleen McMahon. So now the case is up at the Second Circuit. I communicated with the Second Circuit in writing on July 5th, 2017, and July 17th, 2017, and I got the clerk of court, Miss Catherine O'Hagan-Wolf, telling me she's not going to put my communications, and I provided a courtesy copy for the judges and said, "Listen, you can't rule. I'm sorry to inform you that you can't rule on this case because the lower district court lost jurisdiction. Once the lower district court loses jurisdiction by falsifying the record intentionally, they can't break in the law. They can't transfer jurisdiction to you. How can you review what went on? You can't even see what went on because the physical document was removed and the description of the physical document was obliterated. You're blind. You have no idea what happened." So I communicate with the Second Circuit. I provide courtesy copies to the 3-panel judges. I provide a courtesy copy to the clerk of court. I regret to inform you that you can't go forward in this case. And Ms. Wolf says, "I'm not filing your documents." I'm like, "You know something, lady? I don't have to fight with you. I'll just write to the judges privately. I can do that. 18 U.S.C. Section 4. These are crimes. I have the right to report to any judge or military officer. I'm doing so." And then she starts telling me how she controls the mail, and she's going to control what the judges see and what they don't see. I even have a conversation with the chief judge assistant where she's coaching me and how to work around that. I'm like, it's not the job of the clerk of court to control what the judges see and what they don't see, to manipulate the outcome of cases. That's obstruction of justice. That's an interference with the independent judiciary. So is the staff attorney when they engage in the unauthorized practice of law. But if the staff attorney had looked at the lower court record, she would have seen that. So the staff attorney has committed an affirmative act of fraud. So I called all of them and said, I'm the one who went down and dug out the Supreme Court case that says I'm a non-party witness and I can challenge the jurisdiction, and I am. And so is all my producers, because you're not fabricating a false federal court ruling to create an artificial barrier to everybody else. So this can be used nationwide, so that any producer in public access who criticizes, Paul Fishman, who criticizes a public official, can be arbitrarily banned, because that's what happened to Dee Halleck. She made a political commentary, a criticism, and she got banned unlawfully. You're threatening our free speech rights all over the place. And now, in everything I've described, you've just violated our rights to redress. But let's get back to me and my stupid criminal case.
Okay.
So the Second Circuit Court of Appeals, the case is stalled. It's not going forward. The producers all got together, quoted the Supreme Court ruling, and they're just going to shove it down Wolf's throat. And remind her that as the clerk of court, she does not interfere with communications to judges. And I don't care how corrupt those judges are. You do not have some clerk of court, a bunch of clerks controlling the flow of information to you so they can manipulate you.
I thought you wanted to get back to your case.
Yeah, let's get back to my case. So the Halleck case is stalled, and Halleck has been exposed that she's not fighting for herself or trying to get an outcome. She's just colluding with Robert Perry and the plaintiffs, which is the city of New York, to fabricate some impermissible ruling and an impermissible friendly lawsuit to fabricate a ruling that has no basis in fact or law. You remember this because that's the same thing that Judge Robert P. Patterson Jr. did. He fabricated a ruling that had no basis in fact and law, and the Second Circuit upheld what? A former student can't access and correct their records? Oh, give me a freaking break. So now it's August. Oh, and how did they do the fraud? They got some staff attorney running around behind your back. Go into judges, presenting a summary of your case. They don't even know the facts. They misconstrue the facts. Who the hell is the staff attorney running around? Some attorney who can't get a job, so they created another layer of fraud. The judge wants to know anything. The judges can talk to me. So now we're back at the lower court. And it's August, and it's September 1st, 2016. And Magistrate Pitman's first job is supposed to be to look at that information that Stephanie Lake filed, which is a fraud, and say, oh my goodness, this has not obtained the jurisdiction of the court. It hasn't obtained the subject matter jurisdiction of the court. Subject matter jurisdiction cannot be waived. Sua sponte, without even being asked, I'm supposed to dismiss this thing. But he doesn't do that because his whole game is to continue the Soviet Union show trial, the farce, to drop kick Miss Radin into prison so that James Howard can get away with his crimes. So that Yeshiva University can get away with their crimes. So Dan Rizal can get away with his crimes. So John Scarfone can get away with perjury. So that Alex Spiro can get away with suborning Detective Cologne's perjury. So, Magistrate Pitman, September 1st, 2016. It's on the public record. It can't be missed by the staff attorney up at the Second Circuit Court of Appeals. The staff attorney is supposed to be running, not walking, but running to the three-panel judges saying, oh my God, a magistrate judge just broke the law. She needs a writ of prohibition immediately as of right, no discretion. Oh, you want to twist it and say it's a writ of mandamus? Nothing could be more prejudicial to me than a magistrate judge who knowingly, intentionally, willfully, with evil in his heart, with malice aforethought, goes down and breaks the law. So she needs a writ of mandamus as of right immediately. She's got Barbara Moses breaking the law. She's got Deborah Freeman breaking the law. She's got Peck breaking the law. And she's got Henry Pitman breaking the law. Four magistrate judges breaking the law, making war on our government of laws, an irreparable harm that can never be remedied. There is no way to address that. And then there's the harm to me. Oh, and who's colluding and conspiring in this? Stephanie Lake and Michael Ferrara and Justin Green and Max Valles and Sherry Robinson and Shane Doyle, who's falsifying intelligence reports. Oh, and the Homeland Security officers, including their supervisor, Supervisor Barnes, who I talked to too, and threatened me, instead of doing his job, which is to protect me from these crooks who have no right to hold public office because they break the law over and over and over again and demonstrate that they're extreme sociopaths and dangerous to others. So on September 1st, 2016, Magistrate Pitman broke the law. He had no authority, no jurisdiction. He acted in defiance of law. 18 U.S.C. 2384, felony sedition, and he threatens me so he can instill fear in me, so he can terrorize me in acts of domestic terrorism, so I can come down and continue to engage with a farce, so there can be some pretense to put me in jail, to murder me, because that's what I lived through for the 11 months at Rikers Island. Are you not getting the game here, Paul Safier?
You're talking about things from still a year ago, and you're not in jail.
Oh yeah, because I managed to organize enough of a resistance. That's garbage. Everything that happened after September 1st, 2016 is unlawful. They can't go forward. And then I turned them into the FBI on September 7th, 2016. And I want to know what the FBI did about it. I want to know how they got slapped.
You'd have to call the FBI.
Yeah, they all know about it, because I've had beautiful audio tapes and videotapes of that too.
I see your email distribution list is...
That's right, Karen Argent at the FBI. Pardon me?
I said your email distribution list here is extensive.
That's right. Exposing all of the criminality, the massive fraud, is part of what's keeping me alive.
I mean, I don't even know most of these people.
They're judges. They're standby attorneys. Gary Hunt was reporting on criminal defense attorney Marcus Mumford was subjected to the same fraud in Oregon when he was fighting for the Bundys. The Bundys are fighting for over 10 years with highly placed officials in the Democratic Party who are trying to steal their land. Directly analogous to Chuck Schumer threatening me because he's involved in federal student loan fraud.
Well, where have you gotten with the FBI?
I don't think that's a question I'm going to answer right now.
Okay, that's fair.
So now we have Stephanie Lake, who purports to submit a superseding information. She can't. Federal Rules of Criminal Procedure Rule 7, I think it's E. She's changing the offense. She's going from an accusatory instrument has to have a fact and then an offense. You want to change the offense to lessen the degree, you can do that, but the facts have to stay the same or you can't supersede. So she's going from a different fact pattern, you assaulted a federal officer or you pushed a court security guard, to, oh, you didn't listen to his order. That's bullshit. He has no right to order me to not to be on an elevator. Robert Perry could have cared less. Robert Perry was coming out of the hearing and we were having a sidebar. I'm an attorney I'm characterized as an attorney under the CPLR, Section 105. I'm prosecuting my own case. So is Dean Lauren. We're having a sidebar, and the private court security officer is interfering. Why? Because he's communicating with his handlers in the Marshal Service to try to build on my unlawful conviction. She's harassing people. She's harassing. That's garbage. It's just a cover so they can try to get another charge on me. Because they all know I didn't harass anybody in the state conviction. That's garbage. I have a legitimate purpose. Who are you charging me with harassing? The attorneys I caught in perjury and fraud and crimes? That's garbage. I have a legitimate purpose in contacting my school and other officials to stop federal student loan fraud and other crimes against me. That's garbage. And Alex Spiro knows he's not going to get away with it. So on January 28, 2016, when I'm having a sidebar to discuss the litigation points with Mr. Perry, which I didn't even talk to him, Dean Lauren was going, how come you're not talking about Manhattan Borough President Gail Brewer? I don't get this. She is a state actor. They have coercive control. You got some court security officer who's being told by his handlers, get Reedon. Get her, get her, get her! Perry didn't ask him to intervene. That's garbage. That's just an excuse. We're trying to leave. I'm trying to get on an elevator to get away from Crazy Man Panea, who, by the way, I understand was asked to leave the NYPD, and all that information was not provided to me, which is Brady material. And then they trump up some sort of excuse. You can see him blocking my exit. When he blocks my exit, he falsely imprisons me without a reason. I'm trying to leave the federal courthouse. Oh, yeah, that's right. He's following me based on an alert. Where did the alert come from? The marshal's alert came from James Howard on February 4th, 2015, when I knocked on the door of the federal grand jury and did not seek unauthorized access to the grand jury rooms because I was filming lawfully in the halls. Said I'm a crime victim. I have stipulations. The school stipulated to fraud, discrimination, hate crimes against me. I have every right to go to the federal grand jury. And James Howard doesn't want me going to the federal grand jury because he knew about it since 2009. And so did all the marshals. I gave them irrefutable documentary evidence. And had they done their jobs, I never would have gone to jail in 2010, never been beaten, never been almost killed. Of course, James Howard doesn't want me going to the grand jury. He's going to get indicted. So where did the marshal's alert come from? It came from Deputy U.S. Marshal James Howard, who created an alert. And it's based on fraud, because I never sought unauthorized access to the grand jury rooms. And I have the videotape to prove it. And it's up on the internet. And it's not unlawful to film in the halls of a federal building for news purposes.
So getting back to your case.
Oh yeah, Magistrate Pittman. When now he's accepting a superseding information. You know, after I turned Magistrate Pittman into the FBI, after I turned Stephanie Lake and Michael Ferrara into the FBI on September 7th, 2016, all of a sudden we get a superseding information. And the superseding information, it likewise is unlawful, because according to the Federal Rules of Criminal Procedure, Rule 7, if you're going to change the offense, you can't supersede. The offense is supposed to be based on the same facts, and this is the first information. The superseding information is likewise a fraud, and Magistrate Pittman cannot rule on it because, as a magistrate judge, he is not empowered to rule on dispositive motions like a motion to dismiss. The only thing Magistrate Pittman can do is write a report with recommendations, put it on the public record, and then I get to object. And when I object, then it goes to a federal district judge. Magistrate Pittman incriminated himself on the record on September 23rd, 2016, when I asked him, who is the federal district judge assigned to this case? This case purportedly started as a Class A misdemeanor. Who is the federal judge assigned to this case? And Magistrate Magistrate Pittman on September 23rd, 2016, stated on the record, there is no federal district judge assigned to this case. He incriminated himself, and he continued to incriminate himself when he started to rule on a motion to dismiss. And I even asked him, take the bond off. The bond is a fraud, and it's based on the first information. The first information is a fraud. It charges 18 U.S.C. 113, which is a punishment, not a crime. So you got a bond compelling my appearance, threatening me with arrest, and potentially getting beaten up by these crooks again, built on an information. The bond is a fraud. It's based on the information that's a fraud. And what does Magistrate Pittman do? He goes, nah, I'll take the bond off and you can go to jail. You can't put me in jail because the bond is a fraud and the information is a fraud. And the superseding information is likewise unlawful. But Magistrate Pittman, you broke the law, because as a magistrate judge, you are not empowered to rule on dispositive motions. And I found 4 criminal cases going back to 2002 where Magistrate Pittman demonstrates that he knows the law and he can restrain himself, because in those cases, he did a report and a recommendations. He is not empowered to rule. Once he does the report and recommendations, I get to object, and after I object, it goes to a federal district judge. They don't want it to go to a federal district judge because then their federal ticket scam is exposed. They want to keep it at the lower level, at the magistrate level. So, May 22nd, 2017, Magistrate Pittman broke the law. Everything that happened after that is unlawful. A judgment from a court that broke the law, that lost jurisdiction, is void. It doesn't matter what happened at trial. It doesn't matter what happened after trial. May 22nd, 2017, Magistrate Pittman did not err. He did not make a mistake. He got up with evil in his heart, with malice aforethought. He went down, he put on his nice little suit, and he went down to the courthouse, and he knowingly, intentionally, willfully, with criminal intent, broke the law to persecute Miss Radin and deep six her into a jail cell because I caught him breaking the law on September 1st, 2016. There is nothing more prejudicial than a magistrate judge who's trying to get rid of a witness against him. That's obstruction of justice. So, Paul Safier, why don't you call up Shane Doyle, who's got all the information on the public record on her fingertips, and Jason Brasgala, who admitted on the witness stand that he destroyed videotape evidence because he's trying to hide the DOJ people who were involved on January 28th, 2016. Why don't you call all the nice U.S. Marshals over the Southern District and say, there you go. Barbara Moses broke the law. Deborah Freeman broke the law. Magistrate Peck broke the law. Magistrate Pittman broke the law. Let's go. There you are. There are your crooks. Instead of persecuting Lydia Radin.
You sent the email direct to Shane.
Yeah, let's see her act. But she can't because she incriminated herself. Really? She's filing intelligence reports that are fraud? You know who sits on the Court Security Committee? Preet Bharara, Loretta Preska, Chief Judge Loretta Preska, Chief Judge Colleen McMahon, U.S. Attorney Preet Bharara, Acting U.S. Attorney June Kim, the Clerk of Court Ruby Karadzic, U.S. Marshal Michael Greco, the Chief Magistrate Judge, that would be Deborah Freeman. They all sit on the Court Security Committee, and they're all looking at, because they all have access to the electronic database of center violations tickets, where men and women are charged with assaulting a private court security guard, 18 U.S.C. 111, assault on a federal officer, and private security guards are not federal officers. And the fraud is, they're special deputy U.S. Marshals. Their special deputization papers state explicitly that they're not employees of the federal government and they're not appointed. They are not federal officers for the purposes of charging 18 U.S.C. 111 assault on a federal officer. So all the people involved know that that's a fraud. The federal defenders know it's a fraud. I got Sylvie Levine to admit, we see tickets like this all the time. How many of those people pled guilty? How many people did jail time on federal tickets that are never used to open a case? Preet Bharara is the distinguished scholar at NYU. He's a crook. He was fired for cause. So was Paul Fishman in Jason Berg's case. Jason Berg was indicted for assaulting a federal officer, court security guard Donna Dio. Donna Dio is not a federal officer. And they've been hiding his special deputization papers for going on, 2 years now? They're hiding Brady material? How much money have they spent on the Berg's case? How much money have they spent on mine? How many laws have they broken to make war on our government of laws? And Shane Doyle's doing what? Sitting at the prosecutor's table watching Magistrate Pittman break the law? You're kidding me. Shane Doyle's a crook. Max Vallis is a crook. Justin Green is a crook. Stephanie Lindsay Lake is a crook. As an initial matter, Miss Radin was never placed under arrest, and Magistrate Pittman is looking at the videotape where the handcuffs are being put on me? It's a Terry stop. No, it's not. I am in handcuffs. I'm not free to leave. The guy beat me up. And Magistrate Pittman is doing what? Blinding himself? Playing along with the Soviet Union's show trial, the farce, so he can rule on dispositive motions? Magistrate Pittman proceeded without authority. He is proceeding without authority, and he threatens to proceed without authority because I just did an arrest of judgment motion. You can't supersede the information. The information is a fraud. It failed to obtain the jurisdiction of the court. Stephanie Lake cannot cure the jurisdictional defects by filing a superseding information. She had to do something else. The facts in the superseding information changed, and the charges changed. You cannot supersede the information, which is a fraud on its face. You want to know how bad this is? And she makes reference to USA versus Davis. USA versus Davis was a guy who was charged with a federal assault, 18 U.S.C. 113. But 18 U.S.C. 113 is not a federal assault statute. It states a punishment, not a crime. And the case went all the way up to the Second Circuit, and the Second Circuit perpetrated the fraud. And you want to know who the trial judge was? John Gleason in the Eastern District. So I called John Gleason. This is a fraud. And here's how the fraud works. The statute says, if you are found guilty of blah, 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 here's what happens, blah, blah, blah. But in their submissions to the court, they stated it as, if someone commits. The words commit do not exist in the statute, 18 U.S.C. 113. 18 U.S.C. states a punishment, not a crime. And the Second Circuit Court of Appeals made up excuses. And then I called John Gleason and said, you have a responsibility. You have duties of truth-telling to the tribunal. You're the trial judge. You're supposed to go down and correct it. Because USA versus Davis is a fraud. It's a fraud by the Second Circuit. Davis was never charged with a crime. You know, he's in jail right now for 4 years. I hope he's alive, because God forbid anything bad happened to him. And John Gleason, the big judge, said no. I know there's an innocent man in jail. They didn't, even if he was guilty, it don't matter. Two wrongs don't make it right. I know there's a person in jail. I know he's there unlawfully, and I'm not going to correct what I'm going to have everybody believe is a mistake. But at the point I call him on it, it's not a mistake. It's intentional. USA versus Davis is a fraud. It's not controlling on my case or any other case. But the prosecutor wants it to be there so they can say, oh yeah, if an FBI agent says something, it must be the truth. They can tell it whatever lie they want. No, they can't. Oh, a federal officer can say anything they want. Oh, we'll just believe it as common knowledge. No, they can't. You didn't check your brain cells at the door. You go to your courthouse in Newark. You go to your courthouse in Trenton. And you ask to see the public record, the docket, for Central Violations Bureau tickets. There isn't any, because they never open a case. They did the same thing with Marcus Mumford, criminal defense attorney in Oregon. They never open a case. There's no docket number. Men and women are given tickets. They go down to the federal courthouse in good faith. And the prosecutor who never opens it, and they go down with a notice to appear letter, which does not obtain the jurisdiction of the court. They never get a summons. You can write rejected for cause on the notice to appear letter. According to Morris federal practice, which is just a reminder letter, it can be safely ignored. It does not obtain the power of the court. You can go down there. It's a fraud to try to get personal jurisdiction over you. They can't obtain personal jurisdiction because they never opened a case. So you go down with your little reminder letter, and there's like 10, 15, 20 people every month in Central Violations Court. And Chief Magistrate Judge Deborah Freeman knows I'm going to be there every single month going, really, you're down here with a notice to appear letter? What's the docket number? How'd they open the case? Why are you here? The prosecutor's lying to you. His job is to try to bully you and say, oh, we could charge you with $250, but if you just give us $75, we'll drop everything. And stupid little sheep will do it. 90% of them get bullied, get taken advantage of, get preyed on with their trust and their ignorance, and the case is never open. That's a massive fraud by the DOJ. And every single month in the Newark courthouse, and in the Eastern District, and in the Southern District, 10, 12, 15 people come down with their little notices to appear. There's never a case open. And Vincent Bambino and Daniel Ortiz at the Southern District of New York smiled in my face in affirmative acts to further the criminal conspiracy, stamped, filed on my paperwork, wrote in the date, initialed it, signed it, D. Ortiz, and pretended they were filing my paperwork in a case that was never opened. They need to have mental competency exams. They're extreme sociopaths. You know who else needs a mental competency exam? Magistrate Peck, Andrew J. Peck, who on August 26, 2016, purported to dismiss 3 tickets on cases that were never opened. That's his affirmative act of fraud. Oh, and Stephanie Lake was the one who went down on August 10th, 2016, and asked Magistrate Peck to dismiss 3 tickets that were never used to open a case, so she could engage in even more affirmative acts of fraud and deception and trickery and deceit while she broke the law. What are you doing about it, Marshal? I would suggest you run, not walk to Juan Matos Jr. I would suggest you run, not walk to Judge Linares and tell them, and I would suggest that you contact whoever you need to contact and have Magistrate Moses, Freeman, Peck, Pittman, Stephanie Lake, and Michael Ferrara brought up on charges because they're breaking the law. It's irrefutable.
You say as much in your email and your declaration.
Oh wait, I'm working on more. And with that deadline, you got any questions? Because I got a deadline to meet.
Do I have any questions?
Yep.
I don't have any questions.
Okay, feel free to call me. Bye.